There is a woman named Aria who spent 11 days looking over her shoulder, checking her door, praying the police would do something about the man showing up outside her apartment building. He had a record. Police had been called twice. She had a restraining order on paper that said he couldn't come within 500 feet of her, and that piece of paper meant absolutely nothing to a man who decided to ignore it. So Maria walked into a gun store on the north side of Chicago with cash in her hand and that restraining order in her purse, and she asked for something simple, a legal registered handgun that was hers. The background check took 12 minutes. She passed with nothing, clean record, no flags, nothing to stop her. Then the dealer told her to go home and wait. Illinois law required a 72-hour hold. Before that came weeks of paperwork just to get the card that let her walk through the door in the first place. 3 days of waiting while the man she was afraid of was doing whatever he wanted. He had no waiting period. He had no background check. He had her address and no reason to believe she could fight back. That gap, that impossible, maddening gap between a right the Constitution gives you and the permission structure to state builds around it, is exactly what the Supreme Court of the United States decided to address on July 16, 2026. And when I tell you what happened that day, I need you to understand that the mainstream media has already buried the lead, already minimized the significance, and already moved on to their preferred narrative. The case is called United States versus Henderson, consolidated cases from multiple states, all decided in one shot. And what came down that morning was the most significant Second Amendment ruling in American history. If you are not already subscribed to this channel, hit that button right now, because most people watching the news tonight have absolutely no idea this happened. And I'm about to tell you why that matters more than you think. Chief Justice Roberts wrote the majority opinion. And here is the part where you need to stop and pay attention to what actually occurred. Every single justice signed it. All 9, Thomas, Allo, Barrett's, Kavanaugh, Gorsuch. And then this is the part that should make you understand that something fundamental shifted in American law. Sonia Sotomayor, Elena Kagan, Ketanji, Brown, Jackson, the 3 justices who have voted to uphold gun restrictions every single time they got the chance. The 3 justices who were on the losing side in Bruin, they signed this opinion, they put their names on it. That does not happen by accident. That does not happen because justices just decided to see things differently over coffee one morning. That happens when a legal position has become so fundamentally indefensible, so completely disconnected from the Constitution and constitutional history, so poorly justified even under generous scrutiny, that the people who built their entire public legal reputations on defending that position look at the record and decide they cannot write a dissent that holds together, that they cannot in good conscience challenge the reasoning, and so they sign. When that happens, it is not a narrow victory. It is a capitulation. It is the legal equivalent of every constitutional scholar who opposed this position looking at the argument and saying, we cannot win this fight. The law has moved against us and we have to acknowledge it. The ruling established that strict scrutiny, the highest level of constitutional review that exists in American law, applies to all Second Amendment restrictions going forward. This is not a bureaucratic adjustment. This is not a minor procedural shift. Strict scrutiny is the exact same standard courts use when the government tries to restrict free speech or when it tries to restrict religious practice. Think about that for a second. Think about what it means that we had a lower standard of review for one constitutional right than we use for others. Under strict scrutiny, the government has to prove that whatever restriction it imposes serves a genuinely compelling government interest. It has to be narrowly tailored to actually achieve that interest. And there must be no less restrictive way to accomplish the same goal. Most gun laws that exist today were not written to survive that test. They were written under a much weaker standard called intermediate scrutiny, where courts largely deferred to whatever legislators claimed they were trying to accomplish. If lawmakers said a waiting period made people safer, courts accepted it. If states said permit-to-purchase systems kept guns out of dangerous hands, courts took them at their word. That era is finished. Roberts made that explicit. The language in the opinion is not vague. The language is not ambiguous. It says the default is liberty. Restrictions require the highest level of justification. And then it says this: government may not condition the exercise of this right on permission, approval, or delay beyond what is necessary to verify eligibility. Read that sentence again. Read it slowly, because that one sentence just invalidated systems that tens of millions of Americans have been living under for decades. Entire state permitting bureaucracies, entire fee structures, entire philosophies of gun control that were built on the assumption that people need government permission to exercise a constitutional right. That is gone legally, constitutionally, permanently gone. 5 distinct categories of gun law were struck down, not weakened, not sent back for reconsideration. Struck down as facially unconstitutional. The first is permit-to-purchase systems, the exact mechanism that held up Maris purchase for 3 days. Illinois had the Floyd card, Massachusetts had one, Connecticut, New Jersey, Maryland, Hawaii, Rhode Island. All of them required that before you could legally buy a handgun, you had to get permission from a government official in the form of a card or certificate or some form of bureaucratic approval. The court called them prior restraints on constitutional rights. That is the language courts use when the government tries to require a license before you can publish a newspaper. Think about what it means that we allowed that standard to apply to a firearm for this long and called it reasonable. Think about the woman who wants to protect herself but has to wait weeks for paperwork because the state decided she needs a card. Think about the person in a dangerous situation who cannot exercise their right until bureaucracy catches up. That is done now. It is unconstitutional. The second category is waiting periods beyond the time necessary to run a background check. California had a 10-day hold. Florida had 3 days. Rhode Island had 7. The court drew a clear line. The government can run a background check. While that check is running, yes, there is a natural delay, but the moment that check clears, the person is verified, the firearm is theirs. Anything beyond that, any mandatory cooling off period, any administrative hold with no function related to eligibility verification is an unconstitutional delay on a constitutional right. Tell that to Maria. Tell that to every woman in a rural county who lives 45 minutes from the nearest gun store and now has to make that drive twice because the state decided she needed days to think about whether she really wanted to protect herself. Tell VAT to people who face genuine threats and cannot access their rights until arbitrary waiting periods expire. Those waiting periods are gone. Third is mandatory training requirements as prerequisites to ownership. States cannot require that you complete a government-approved course before you can exercise your Second Amendment rights. The court was careful here. Training can be offered, it can be encouraged, and it can even be subsidized by the state. What it cannot be is a gatekeeping mechanism. The moment you make completing an 8-hour class a condition of owning a firearm or carrying one, you have turned a right into a licensed activity. Rights do not work that way. You do not have to pass a civics test to vote. You do not have to take a journalism course to operate a printing press or start a blog. You do not have to get government permission to speak. The Second Amendment is not different. If it is a constitutional right, it cannot be conditional on completing a government-mandated course. Fourth is the good cause and proper purpose requirement. The system that turned the most restrictive states into absolute labyrinth. California had this, Hawaii had this, Maryland had this. Certain jurisdictions in other states had it. What they required was that before you could get a carry permit, you had to prove to a government official that you had a documented specific need for self-defense. You had to show that your life was in danger. You had to get a letter from law enforcement. You had to provide evidence of threats. You had to prove victimhood before the government would allow you to prepare for it. The court said, no, the right to bear arms is not conditioned on demonstrating that you are already half dead. You should not have to wait until a threat becomes dire before the government allows you to exercise the rights the last constitution already gave you. That is gone. And fifth is discretionary denial systems. Any permit structure that gives officials subjective authority to approve or reject applications based on their personal judgment about your suitability. Shall issue means shall issue. If you meet the objective criteria, you are the right age, you have no disqualifying background, you are not prohibited by federal law, they hand you the permit. That is it. No character assessments, no interviews, no background checks on your behavior at the grocery store, no official deciding that you just do not seem like the kind of person who should be armed. That discretionary authority is gone. Those 5 categories represent the structural spine of gun control in the most restrictive states in the country. They are the systems that were built to make it as difficult as possible for people to exercise their rights, and they are all gone. The effect of this ruling is not the same in every zip code, and it is important to understand that clearly. If you live in Texas, Arizona, Tennessee, Wyoming, or any of the roughly 25 constitutional carry states, your day-to-day legal reality probably changed very little. Your state was already aligned with what the court just mandated. You might see some cleanup around the edges, but nothing seismic, nothing that fundamentally alters how you access your rates. If you live in Washington, Oregon, Colorado, Michigan, Pennsylvania, or Florida, you are in the middle ground. Some waiting periods disappear, some training mandates are gone, some local discretionary systems become unenforceable, but you do not have the full permit to purchase architecture that defined the most restrictive tier. Everything hits different if you live in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island. You just watched your state lose 10 or more major restrictions in a single morning. California's 10-day waiting period drops to background check time, which runs anywhere from minutes to a couple of hours, depending on the system. The Firearm Safety Certificate, their version of a permit to purchase, is no longer a legal requirements for buying a handgun. The May issue counties, the jurisdictions where sheriffs had been running what amounted to private veto systems over who got to carry, those are finished. They cannot say no anymore. New York's Concealed Carry Improvement Act training requirements are void. Illinois' Floyd card system, the exact thing that kept Maria from getting armed faster when she needed it most, is struck down. New Jersey's permit-to-purchase structure is invalidated. Massachusetts loses its permitting system. These are not abstract legal changes. These are states losing the machinery of control they built over decades. Here's where I need you to pay very close attention, because this is the part that determines whether this ruling protects you or gets you arrested. The Supreme Court issued this ruling. That ruling is the law. But the systems in these states do not automatically disappear the morning after the decision. Gun stores in California did not wake up on July 9th running under new rules because a dealer printed out the opinion and taped it to his wall. State attorneys general do not instantly reorganize their operations. Local law enforcement does not automatically update training. County clerks do not get overnight directives about new procedures. Gun stores and permitting officers operate on their own timelines, and those timelines are slow. Some jurisdictions are moving toward compliance immediately. They understand the ruling is clear, and they are reorganizing. Others are waiting for guidance from their state governments, hoping that guidance clarifies how to proceed. And others are being told explicitly by their governors to maintain current procedures while the state assesses its legal options. In other words, they are being told to keep enforcing the laws that were just ruled unconstitutional. This means there is a gap right now, potentially weeks, potentially months, between what the Constitution says you can do and what your local government will actually let you do without arresting you. If you live in one of these states, do not walk into that gap. Assuming the ruling is a shield, you can wave at a police officer. It is not a Supreme Court opinion, is not a magic document that stops a police car or prevents an arrest. What it absolutely is the strongest foundation that has ever existed for a civil rights lawsuit after the fact. But after the fact means after you have been charged, after you have hired a lawyer, after your life has already been disrupted, after you have had to go to court, after you have spent money and time and emotional energy proving what should have been clear from the beginning. Know what your state is doing right now. Know whether your local officials have issued compliance guidance. Know which sheriffs are updating their procedures and which ones are quietly maintaining the old system and daring people to challenge them. Act on the rights that the ruling recognizes when the system is actually ready to honor them, not the moment you feel like the ruling should protect you. Subscribe right now if you have not already, because over the next several weeks, I am going to be tracking exactly which states are actually complying with this ruling, which ones are stalling, and which ones are busy building legal workarounds designed to technically satisfy the court while functionally maintaining the same barriers they just got forced to tear down. The media coverage of this ruling has been, in a word, disgraceful, not because it was inaccurate in the narrow factual sense. Most outlets correctly reported the vote count. They got the basic holding right, what they buried, what they minimized. What they in some cases refused to address directly was the significance of the anonymity. I have watched every major outlet that covered this story. Most of them mentioned the 9-0 vote in passing. They treated it as a footnote, and then they spent the majority of their coverage on gun control advocates expressing concern. Gun control advocates do express concern. That is their job. But not one of the primetime broadcasts I watched led with the actual story. Not one asked the question that every serious legal journalist should have been asking the moment the opinion dropped. Why did Sawyer, Kagan and Jackson sign this, Perry? These are not swing votes. These are not justices who occasionally break from their ideological alignment on edge cases. These are 3 justices who have built their entire public legal reputation, in part on the position that reasonable gun regulations survive constitutional scrutiny. Sawyer wrote scathing dissents in Brain. Kagan has been explicit in opinions and in public commentary about her view that courts were overreading the Second Amendment. Ketanji Brown Jackson came to the court after Bruin and has never once voted to expand gun rights. And then on July 8, 2026, all 3 of them signed an opinion written by John Roberts that establishes strict scrutiny for the entire Second Amendment and strikes down 5 foundational categories of gun control law. There's only one reason that happens. The restrictions being challenged had become so legally indefensible, so completely disconnected from any historical tradition, so poorly tailored to any compelling government interest, so impossible to justify even under generous scrutiny, that these 3 justices looked at the record and decided they could not write a dissent that held together logically. They could not defend it. They could not make the argument work. And rather than put their names on something they did not believe, they signed on to the majority. That is not a political statement. That is a legal conclusion. And the press, which has been covering gun law through a political lens for so long that it is forgotten there is a constitutional lens, missed the story entirely. What Roberts wrote is not a narrow holding. The language he chose will be quoted in federal courts for the next 50 years. The default is liberty. Government may not condition the exercise of this right on permission or delay beyond eligibility, verification. That language puts assault weapon bans, magazine capacity limits, age restrictions beyond the federal minimum, and red flag laws without robust due process procedures, all squarely in the crosshairs of strict scrutiny challenges that are now substantially more viable than they were on July 5th. The press did not explain that, and they gave you the vote count and the outrage takes. They did not give you the legal architecture that was built inside that opinion and what it means for every gun restriction that was not directly struck down today, but is now standing on a foundation that just cracked wide open. So, here's what comes next. And I want to be very precise about this because there is a version of the story being told right now that overstates the victory and a version that understates it, and both will lead you wrong. The constitutional question at the centre of Henderson is settled. Strict scrutiny applies. The 5 categories are gone. Those facts are not going back. No lower court can relitigate them. No state legislature can pass a law that undoes them. The Supreme Court spoke unanimously, and that is about as settled as American law gets. What is not settled is the second wave. The states that lost the most are not accepting this quietly, not even close. California's Attorney General has already announced the state is reviewing its options. That is code for building a workaround. New York's legislature was in emergency session within 48 hours of the ruling drafting replacement restrictions. Illinois, New Jersey, Massachusetts, all in the same posture, publicly saying they will comply while privately crafting replacement systems designed to create the same functional barriers through different legal mechanisms. They will replace permit to purchase with mandatory free training that takes weeks to schedule and is only offered in limited locations on days when people cannot attend. They will replace waiting periods with cooling off language tied to mental health screening processes that conveniently take 7 to 10 days. They will replace may issue with shall issue, plus 20 objective requirements, each of which requires documentation, fees, and processing time. They will rebuild the wall with different bricks and dare the courts to knock it down again, and the courts will knock it down again. But that takes time. That takes litigation. That takes money. Strict scrutiny is not a one-time application. It is a standard that has to be applied to every restriction, including the new ones that states are right now constructing. Every workaround law these states pass will face immediate litigation from the Second Amendment Foundation, the Firearms Policy Coalition, and a half dozen other organizations that were ready for this decision and are already mapping the next rounds of challenges. Those challenges will go through federal district courts, through circuit courts, and some of them will go back to the Supreme Court. That process takes years. During those years, the workaround laws will be in effect in the states that pass them. People who try to exercise the rights that Henderson recognized will run into the new barriers and have to decide how to respond. If you care about this decision actually being enforced, if you believe the ruling matters, if you think people should actually be able to access the rights that 9 justices just unanimously said are theirs, then support the litigation organizations. Support them not because I am telling you to or because you need someone on the internet to validate your politics. Support them because they are the actual mechanism by which this ruling gets enforced. When states decide not to honor it voluntarily, the Supreme Court does not have a compliance department. It does not send federal marshals to make sure Illinois updates its permitting system on schedule. Enforcement happens through lawsuits, and lawsuits cost money. The states have unlimited legal budgets funded by the taxpayers they are restricting. The gun rights organizations fighting these battles do not have unlimited budgets. The gap in resources is real. It is significant. It matters. If this ruling is going to mean anything in the states that are actively building resistance to it, that gap needs to be addressed. There are also restrictions that Henderson did not directly address, and I want to be clear about what they are and what they mean going forward. The ruling struck down the 5 categories I described in detail. It did not directly rule on assault weapon bans. It did not directly rule on magazine capacity limits. It did not directly rule on red flag laws. It did not directly rule on age restrictions beyond the federal minimum. What it did was establish the standard that those restrictions now have to survive going forward: strict scrutiny. And under strict scrutiny, the prognosis for most of them is not good. The government will have to prove that banning certain classes of weapons serves a compelling interest and that it is narrowly tailored to achieve it. They will have to prove that magazine limits are the least restrictive way to accomplish a legitimate goal. They will have to prove that red flag laws, especially ones without robust due process protections, are constitutional. Under strict scrutiny, those become very difficult arguments to win, but not good under the new standard is not the same thing as already struck down. Those fights are coming. They are not here yet. The distinction matters. Rights that exist on paper but require a lawsuit to enforce are still rights worth having. But they are not the same as rights your government is prepared to honour when you walk through a door and ask for them. Know the difference? Insist on the first. Work to close the gap between the two, because that gap between what a court says you have and what the system is actually willing to give you without a fight is where people get hurt. It is where lives get upended. How many more incidents is reasonable? How much more is suffering from people who followed every rule, who had every qualification, who did nothing wrong except try to protect themselves before the system decided they were allowed? The answer the Supreme Court just gave in 9 voices in complete agreement is that it cannot justify it at all. It cannot be justified. The default is liberty. The government has to prove it has the right to restrict it. That is the rule now. Whether the people running these states have the honesty to accept that answer, whether they have the integrity to actually comply instead of building workarounds, whether they will honour rights or fight them, is the question that will define this next chapter of American law. That fight starts right now. That fight is already underway, and you need to understand what is actually happening so you can navigate it. Subscribe to this channel. Hit the notification bell, because I am going to break down every development, every state workaround, every lawsuit that matters, every ruling that pushes this forward or backward. You need to know what is happening in your state. You need to understand the gap between what the law says and what the system actually does. And you need to know whether your rights are going to be honoured when you go to exercise them, or whether you are going to be the next person waiting for a court to tell the government what the Constitution already said. The story is not over. It is just beginning. And everything that happens next depends on whether ordinary people, whether people who care about this ruling, whether people who believe rights matter, are willing to show up, pay attention, and hold their governments accountable for actually complying with what the Supreme Court just